Hello, everyone, and welcome back to the Commercial Awareness Compass. My name is Daniel Shepherd, and I'm an SQE student and future trainee solicitor. Today, we're unpacking the Mazur versus Charles Russell Speechlys court case. In a sentence, paralegals and other non-authorised staff can support litigation, but they cannot conduct it, even under supervision. The Legal Services Act 2007 reserves conducting litigation to authorised people, issuing claims, running or defending them, and the formal procedural steps around them. Mazur makes the line clear. Supervision doesn't create authorization. So why does this matter? It changes who signs and who files. It affects what costs you can recover, and it sharpens what the SRA expects when it asks you who was the solicitor on the record. Practically, it means revisiting task maps, tightening sign-offs, and being upfront with clients about who does what. So today I'm joined by Henry. Thank you for joining us today. So before we start, would you like to give us a brief overview of your background and what you do?
Yeah, for sure. Thank you, Daniel, for having me. As you kindly mentioned, I'm Henry. I am a almost 6-year qualified lawyer, and I am also a content creator and wellbeing advocate.
Amazing. So obviously we've got a lot to unpack with this, and I imagine as a content creator, you've kind of seen that this court case has kind of taken up legal content space.
Yeah, for sure. I'm sure many of those watching or listening to this podcast episode have seen it on their TikTok feeds, over their LinkedIn, and all over the legal press. This has been quite a highly spoken about subject. Sorry, I can't get my words out.
But just kind of to keep it simple, what counts as conduct of litigation under the LSA 2007?
Yeah, sure. So one of the biggest sort of talking points around the decision made by this is what actually qualifies as conducting litigation. And the legislation, the Legal Services Act, sets out quite clearly that conducting litigation is a reserved activity, and non-authorized staff, which is like your unqualified staff within a law firm such as paralegals, are not authorized to carry out in conducting litigation. This can include sort of issuing court proceedings. This can include sort of running, defending those proceedings, and kind of really doing the kind of the meaty tasks that would be sort of carried out as part of the litigation process. And it can also include related or ancillary functions as well, which has caused a lot of discourse around what does that actually include and where can we engage sort of support functions to do this. Because in a lot of, we'll come on to this later, but what a lot of firms do, especially firms that are very litigation heavy, is they have pools of paralegals or case handlers, some of those listening may be doing these roles at the moment alongside their studies, who will do a lot of the litigation process, maybe the sort of prepping the pleadings and all of that stuff. In this case, kind of calls question on to whether or not these firms are actually allowed to get paralegals to do these sort of tasks.
So would you be able to break down when we're talking about conducting litigation, who kind of falls into the authorized categories?
Yeah, again, so in terms of the Legal Services Act, this case has kind of reignited a lot of discourse around who can actually do what. But I think in a nutshell, the litigation, those who are allowed to conduct litigation under the Legal Services Act are, if you think about it in a very simple way, it's qualified staff. That could be barristers, solicitors, chartered legal executives who are qualified, but they may not have cross-qualified over to the solicitor title. But if you're a Silex qualified lawyer, that includes you. Patent and trademark attorneys as well can do these regulated these activities that are deemed as conducting litigation. So that's how the most simple way to think of it is: qualified can, non-qualified cannot.
So we're talking about the Mazur case this week. And as we said before, it's kind of been like a big thing that's kind of shaken the legal world. But what were the key facts and findings in Mazur?
Yeah, in a nutshell, the case really created some kind of uncertainty within the legal profession in firms that rely on, as we just mentioned, non-qualified staff to carry out certain litigation tasks. So this will require a lot of firms. Many of the firms that those listening might be sort of starting to do their training contracts out, or they may be practicing as paralegals at the moment, in what they can and cannot do. So there'll be internal reviews to make sure that the work that they're doing doesn't fall within the scope of conducting litigation, which then in turn results in them being in breach of the Legal Services Act.
So you've talked about kind of what is kind of reserved for those who
Yeah.
are qualified to do so. But would you be able to break down what tasks are classed as assistants, therefore they're okay to do, and then which tasks are classed as conduct and therefore are reserved?
Yeah, again, it's one of those things that this case hasn't necessarily really created this is the one list for the conducting litigation tasks, and this is the other list of what kind of sits outside of this, because within the conducting litigation regime, it was found that conducting litigation, which can only be then carried out by those that are authorized to do so, can involve doing the related or ancillary tasks to managing the litigation, which those terms in themselves create some kind of ambiguity, because related tasks or ancillary tasks, for example, can pretty much, depending on how you look at it and how you interpret it, can be very wide in terms of what it covered. You could argue, in theory, that printing out the pleadings to hard copy file at court, although most things are done online, just the printing out, is that an ancillary function? Are we going to get a fee earner to do a task that could be carried out by somebody who charges a lot less, a paralegal? And then this creates a whole host of different issues for firms and for clients as a result, such as cost efficiency, practicalities, time efficiency.
So I guess it's kind of the vagueness of the rulings what stirred up a lot of the conversation around this, and we'll get into it a little bit more when we're talking about the practical steps that firms are going to take. But if we move to the intermediate section, on a live matter, what
Yes.
actually changes?
I think there will be a whole host of ways. Just come back to your point before, actually, in terms of the level of ambiguity and the sort of the grey area. From memory and from reading around this and following the ongoing sort of online discourse around this, I do believe that there are ongoing challenges to this decision already, and I think we are going to see this ruling in similar cases come up over the next few months, years, as to what's kind of qualified. I think we might, for example, we might see that clients who, this is me thinking glass half empty, and with my cynical hat on, but you may get clients hit with a huge litigation bill, and they may be looking at ways to kind of challenge the bill, and they will see this case as an example, or we might see a lot of challenge to litigation to say this wasn't conducted by an authorized person, this is conducting litigation. What's an ancillary function that's been carried out by somebody who shouldn't? So I think this case and future cases around this topic we're going to see more and more of, which for those that are looking to take roles and to qualify into litigious practice areas, this is going to be a case that you're going to want to follow, because you're going to need to know, who can you delegate to? Can I give this to a paralegal? What book should I be doing? What form should I be signing off? But yes, in terms of, and that kind of leads on actually to one of the things that law firms should be thinking about when conducting litigation, is sort of their supervising duties. Who is actually allowed to supervise? What does this mean? Do they actually have, in terms of their own, how the litigation piece, the matter that they're working on, is supervised? Is it merely just a case of ticking things off, supervising? Do I actually have to fully sort of review things and have oversight of all of the documents, not just simply doing a, yeah, looks fine, all good, no comments, in sending off?
So when we're talking about kind of the delegation, what are the dangers with delegation and kind of what can teams do to avoid that danger?
I think the biggest risk off the back of this case is that if they delegate to non-qualified staff, and just to flag as well, we talk about non-qualified staff in terms of paralegals, support staff, ancillary sort of staff. But in the Mazur's case, for example, the solicitor in question, or the non-authorized staff member in question, was actually a qualified solicitor who had had his practicing certificate revoked, so he wasn't technically on the rolls in qualified per se. So that again is another category of people who would be deemed not authorized, just because on paper well, not on paper, but he was qualified at some point, in had the title solicitor, but because he'd had his practice certificate revoked, he wasn't entitled to be a practicing solicitor and hold his name out as that. So firms need to be reviewing how they're delegating tasks and to whom they're being delegated to. And if we're delegating to non-qualified staff to prepare the first draft of the pleadings, to file documents, or to actually engage with clients and say, these are decisions around your litigation, let's do this, that, or the other, that could, off the back of this case, potentially be in breach of the Legal Services Act, which then causes a whole host of other issues for the firm.
I guess from the perspective of clients, the big thing to call out is costs. That's kind of where clients are going to be looking at their people. Obviously, clients want their costs to be as low as possible, and any ways to do that. I guess a new form has been opened up to challenge costs based upon this. So, how should a firm handle costs and client communications around this?
I guess one of the biggest issues is, or we briefly touched on this earlier, is that if, say, for example, we have got ancillary tasks that need to, under the legislation, be carried out by a authorized individual, a solicitor's time is going to be more valuable in terms of how much it costs in comparison to a legal assistant or a paralegal, whose charge out rate is a lot lower than qualified fee earner. So if we are getting more fee earners spend their time doing tasks that could be done by support staff, paralegals, legal assistants, which charge less, then actually there's a heavier reliance on these qualified members of staff, which in turn means costs will be higher, which ultimately that'll be a bill for the paralegals, not paralegals, the clients. Yeah, the paralegals won't be paying their clients' bills. It will be the clients who will be paying those bills. So operational costs will be driven up. And there's also then the risk of challenge to these bills, that if work is being carried out, litigation is being conducted by unauthorized individuals, then this could be challenged. And this could then potentially risk sort of what sums and monies can be recovered. We could have risks with sort of fee sharing arrangements in terms of, or fee agreements, sorry, and how this looks. So there are a whole host of issues that firms need to be aware of, particularly in light of costs, which when dealing with litigation matters, costs are a huge factor in terms of how litigation is conducted.
That's kind of what's the maybe confusing part of this is the idea of supervision first with compared to authorization and kind of how those work in conjunction with each other. But what does supervision that stands up to the scrutiny actually look like in a practical sense?
From reading around the case and the judgment, I'm not a litigation expert by any means. And although I very much did enjoy my litigation seat, actually, it was my first ever seat as a trainee. And I remember putting, it must have been like 18 to 20 paginated printed bundles together. And you wouldn't get a qualified solicitor doing that because it's costly. And then you'd ask the question, is this conducting litigation? Is this an ancillary task? And then my supervising partner was quite actively involved in my supervision and supporting what I'm doing. So I think it's, from my understanding, you have to take more of an active role. And again, I think we'll see more cases challenge this and bring this to life over the coming months and years. But I think the supervisor needs to be actively engaged in the litigation and the tasks that are being carried out by those to whom the tasks have been delegated to, rather than just simply saying, thank you for doing that, send out. I don't think there can be a level of passive involvement. I think there has to be strong document oversight into it.
I imagine with the timing of the case, kind of a lot of first seat trainees that are in the litigation space at the moment, this must really have kind of taken up their inbox and
Yeah, and I think it can be quite understandably nerve-wracking for paralegals and legal assistants to see this and to think that actually, is the task, is this work that I'm doing, conducting litigation, am I in breach of the legislation? Because my career, I've not even yet qualified. I don't want to start falling foul of those regulations, which is why it's really important that firms are making sure that they are being actively reviewing how litigation is conducted and handled, what their fee earning staff are doing, and to ultimately mitigate any potential risks of non-compliance, because that's sort of what they need to be making sure that they do.
and kind of to round out the intermediate section, when we're looking at the changes that firms are going to make, where does the pressure hit first for firms, and what do you see a lot of them doing to reroute?
I think ultimately firms will be wanting to mitigate their risk and their exposure to falling foul, because, of course, any potential breaches could trigger sort of SRA investigations. There could be misconduct claims. It will be their in professional indemnity insurance that's then on the hook should they be found falling foul. Of this, so they should be doing audits and overhauls if they need to ensure that they are ultimately being compliant, because it will be them kind of it like Charles Russell, Charles Speechlys Russell. Yeah, I got that the right way around. They are on the hook and they're being challenged, and then off the back of that, you then have sort of reputational risks, client confidence. If say, for example, the firm in question here, if they are managing claims for others in terms of their litigation, they quite rightly might be asking the question, well, who's been conducting our litigation? We've just received X bill. Can you please provide an outline of who's done what? Are we going to challenge this? And then there's a whole host of reputational and contractual risks that the firm opens itself up to.
Well, I guess now that we move on to the advanced section, and kind of as a bit of a callback to what we mentioned earlier, this case has garnered like a lot of attention, and lawsuits have come up, that we're going to kind of see how they play out in the next few months. So
Yes.
it's going to be really interesting to kind of see how firms adapt to this when we do kind of get a little bit more. Oh, sorry, if we get a little bit more clarity, which is obviously that'd be nice, but it's not guaranteed. Yeah, so it'd be interesting to see kind of how firms kind of get clarity out of those cases, or how firms can kind of push for more clarity out of these cases.
Yeah, for sure. I think with this case and future cases, that particularly in light of the grey areas around like the ancillary related tasks, I think over time we are going to get greater regulatory development from the relevant bodies to provide sort of clarification, and actually what this looks like from the idea of when you're supporting versus when you're actually conducting, because those that are conducting have to be qualified and authorized. I also think that we might see the rise of more alternative business structures, who generally have broader authorizations to be able to do a lot more. I think that conversely, where a lot of firms that do, I don't necessarily know if they've got like a specific name in terms of the category of work, but they are the low value, high volume claims that you see a lot of certain law firms or claims management companies provide. They rely heavily on paralegals, for example, or claims handlers. A lot of them are referred to in these spaces. That could potentially impact those models of how they operate in terms of low value, high volume. Paralegals run these claims, conduct the litigation. These paralegals are generally paid relatively low in comparison to qualified staff. That can have a huge business model impact. So they may have to kind of restructure this, rethink this, but then in turn, this could impact what clients are paying for this, and it will just increase prices across the board.
Yeah, it'd be interesting as well to see whether firms kind of try and push more paralegals to qualifications, whether that's, the solicitor route or Silex or patent attorney, dependent on the 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 business model they operate in. But yeah, it would definitely be interesting to see, and obviously how that reflects on prices, because even though you're still able to get more people that are allowed to do this work, if you're paying X amount for all of your or the majority of your paralegal staff to get trained up in certain areas, will that be passed on to clients? Who knows?
Yeah, but I also completely agree with you that I'm a big advocate of, if you've got talented paralegals and legal support staff in your teams across your firm, firms need to be investing in their training, and train these junior staff up to qualify in whatever route that works best for them, if that's qualifying work experience, ILEX route, whatever authorization route that may be, to ultimately keep these people within the firm, to be carrying out the relevant work that needs to be done to conduct the litigation within the frameworks of the relevant legislation.
And this might be the only time you hear me say this, but this could be a benefit of the SQE. As in, you've had people that have been paralegals for a couple of years, they've got that experience behind them, and then
Yeah,
they're able to sit these exams and they're qualified faster than it would be having to kind of take the time, then start a 2-year training contract and etc. Though I can't believe myself saying it, there could be an actual positive of the SQE.
yeah. What made me chuckle then, that's why I started giggling to myself, is that you said just sit a couple of exams, and if we look at the pass rates
Yeah.
for the SQE, it might take a few attempts. Um, I do want to try it myself just to see if I can do it. I don't think I would be able to, but I would like to have a go. But yeah, I get your point around it being um, a way that you can have paralegals and support staff working on the job, and having the appropriate tasks delegated to them. But they can also, in the background, be on the route to qualification, and you've still got these people working within the organization.
Yeah, well, I'm currently my SQE prep at the moment, so a couple of exams definitely wasn't the right remark.
It'll be absolutely
But
fine. Sure.
yeah, we'll figure that out later. But kind of to round out, when we're talking about kind of the insurance that firms take out,
Yeah.
what should firms expect from insurers, and how might market dynamics shift with respect to that?
Yeah, we spoke about the professional indemnity insurance earlier, which, for those that don't know, is a level of insurance that those that provides professional services have to have. So we have ultimately, hopefully not, but negligent advice is given and they're sued, this insurance will kick in. But I think firms that operate litigation practices and in any capacity actually, um, they may find that these insurance providers want a greater understanding as to how litigation is being conducted, to who is actually conducting this litigation, and what the delegation practices are within the organization. Because if there's a risk that they're going to fall foul and potentially claims are going to come at them, then ultimately it's going to be the insurance provider who has to cover the costs of those claims. So if there's a risk, then the what do you call it? Their premiums are going to increase, or it may arguably, depending on what the policy says, if there are delegation practices that aren't within the scope of the regulatory regime, then the insurance might not actually cover potential claims altogether, which is a huge risk for firms.
So I guess to kind of go over what we've covered in this story, a lot of it is cost based for firms.
Yeah,
The the they're having to obviously take fee earners and what's it, get them on tasks which usually wouldn't have been done by them, the insurance, the restructuring, the retraining, kind of everything around it seems to be a whole cost base. And it'll be really interesting to see how different types of firms handle this. Because for smaller firms, these cost pressures will be like astronomical. For big firms it will, but they may be able to weather those sorts of pressures. So it'll be really interesting to see kind of the the way that it may create a greater imbalance within the legal industry as we
definitely.
see
Yeah.
with the rising costs.
Yeah, I think for sure litigation off the back of this case is likely going to become more expensive. And I think you're completely right to flag are either smaller organizations. And I think those firms that have operate on like a churn out of certain cases, the low value, high volume cases are going to be heavily impacted by this. But I think hopefully in time we're going to get greater clarification as to what in terms of the grey areas on this around who can actually do what's actually meant by supervision. And I think over time there'll be more cases that kind of scrutinize these points.
And not to put you on the spot too much, but as kind of like final summary question, if you were you said you did your first seat in litigation. If you were kind of speaking to a trainee, they're starting next week in a litigation seat, they've seen this, they're in a bit of a panic, obviously, with the kind of how it's going. What would you say to them? What would you kind of what would your kind of overall takeaway be for advice to them?
My overall takeaway would be that if I were, say, I was starting my first seat tomorrow in litigation, ultimately it is for the firm and the staff at the firm, the qualified staff who are delegating tasks to you, to make sure that they are falling within the scope of the regime. If there are tasks that you're unsure about, ask the question. And also, I think your firm's probably written an article on this. Have a read, speak to people within the team about it, share your thoughts around what you think this case means and says, because if litigation is an area that you want to get into, this is a case that's going to affect you. And I think it really showcases sort of research around the practice area that you're in. I think it shows initiative, but I wouldn't be going in and saying, no, I'm not doing that. That's conducting litigation. That's not for me. But also, I wouldn't stress too much around whether or not you're going to come under scrutiny and get struck off. I think that's a risk or something that the higher ups in your firm should be managing and mitigating risk.
Brilliant. I think that really nicely winds down this episode. So thank you for everyone for listening, and thank you, Henry, for joining us today. So we've discussed obviously Mazur versus Charles Russell Speechlys and the difference between supporting and conducting litigation and what that means for teams, costs, and compliance. It's a reminder that commercial awareness isn't only about headlines. It's about understanding that the rules that shape how legal services are delivered. and how changes to authorisation and supervision can ripple through business models, clients, and consumers. So, as always, ask yourself, how does this affect clients? What can a law firm do to help? Join us next week to keep building your commercial awareness. And until then, prepare without the panic. Thank you.